ಥೆಫ್ಟ್ ಆಫ್ ಜ್ಯುವೆಲ್ರಿ ಇವ್ರು ಹೇಳುದು ಅವ್ರ ಮದರಿಲ್ಲ ಅದು ತಗೊಂಡು ಅವ್ರ ಮದರ್ದು ನಾವು ತಗೊಂಡ್ಬಿಟ್ಟಿದೀವಿ ಅಂತ. ಬೇಸಿಕಲಿ ದಿ ಅಫೆನ್ಸ್ ದಟ್ ಇಸ್ ಅಲಿಜ್ಡ್ ಇಸ್ 1 under section 307
attempt to murder.
attempt to murder. The how the courts have said, my lord, with regard to the attemptees, but for some intervening cause,
302 act.
had the act been completed, ಅದು
302
ಅಲ್ಲ, ಇಲ್ಲೂ ಅಷ್ಟೇ 307 ಆಗ್ಬೇಕಾದ್ರೆ ಬಟ್ ಫಾರ್ ಸಮ್ ಇಂಟರ್ವ್ಯೂನಿಂಗ್ ಕಾಸ್ ಹ್ಯಾಡ್ ದ ಆಕ್ಟ್ ಬಿನ್ ಕಂಪ್ಲೀಟೆಡ್. ಇಲ್ಲಿ ಇಂಟರ್ವ್ಯೂನಿಂಗ್ ಕಾಸು ಇಲ್ಲ, ಆಕ್ಟ್ ಕಂಪ್ಲೀಟ್ ಆಗಿಲ್ಲ. ಐ ಆಮ್ ಶೂರ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ವುಡ್ ಸರ್ಟನ್ಲಿ ಅಗ್ರಿ ವಿತ್ ಮೀ. ಅಟೆಂಪ್ಟ್ ಇಸ್ ಟೋಟಲಿ ಡಿಫರೆಂಟ್ ಫ್ರಮ್ ಪ್ರಿಪರೇಷನ್. ಪ್ರಿಪರೇಷನ್ does not constitute an act of attempt. What is 307 according to them? Attempt to commit murder. How? In what way I did it? There must be a basic minimum allegation for the court to have noticed the commission of a cognizable offense for the purpose of making an order of reference under section 156(3). No. Exchange of messages. Kindly proceed with an assumption for the sake of argument, do not considering for a moment at this point of time that there are certain exchange of messages. Subsequent to the exchange of messages, there must be some act.
So it remained at messages only.
Ashte. My lord, I don't know how your lordship would recall to your lordship's memory under the provisions of the Essential Commodities Act under section 3 and 7. The state government would issue certain notifications
under 7.
prohibiting interstate or interdistrict movement of
Prohibiting many things that. Under 7.
Many, yes.
Which becomes an offense under section 3.
Well, supposing I load the food grain into the lorry, it does not constitute an offense. It is only a preparation. In the last minute, my lord, I may realize, look here, what I am doing is incorrect. I will unload it. Then it will not constitute an offense at all. It is not an attempt. It is only a preparation. Now, attempt for what? Black magic is for what? To see that she is subjected to some kind of torture or harassment.
That is why, if I may say, 399 and 402 are differently worded. Preparation and attempt.
Alve. Innೊಂದು ಸರಿ ನೋಡೋಣ ಇದರಲ್ಲಿ. My learned friend my lord invited my lord's kind attention to schedule class 3 ಅಲ್ವಾ? Schedule 3 ನೋಡೋಣ ಒಂದು ಸರಿ.
Whoever attempts.
ಅಲ್ಲ no my lord. No.
Schedule of the act.
Schedule.
No.
Constitutes offense.
No. ಇದರಲ್ಲಿ ಗೋಸ್ಟ್
under the pretext.
I don't know. Probably in Gudiyaman, my friend might have invited my lord. Under the pretext
expelling the ghost,
assaulting by tying the person with a rope or chain, beating by stick or whip to make the person drink footwear, soaked water, giving chilly smoke, hanging a person to roof, fixing the roof.
Under Milord, under provision
or
2.
by hair or pluck his hair, causing what is all
That is different, Milord, because what happens in our schedule has Milord item number 1 to 16.
ಅಲ್ಲ, ಮುಂದೆ ಓದಕ್ಕೆ ಆಗಲ್ಲ.
ಮುಂದಕ್ಕೆ ಓದಕ್ಕೆ ಆಗಲ್ಲ. ಯಾವ್ದಾಗಲ್ಲ. If at all, my lord, at the worst, if we take the entire my lord allegation to its face value as true, it should come within the parameters of 1, 2 and 3.
Please.
Beyond it ಬರೋದಿಲ್ಲ. I'm sure my learned friend would certainly fairly
ಆಮೇಲೆ
concede.
ಬೇರೆನೇ ಇದೆ.
ಬರೋದಿಲ್ಲ, ಯಾವ್ದು ಬರೋದಿಲ್ಲ. ಒಂದ್ ನೋಡೋಣ performing completion. Inhuman, evil act and black magic in such of precious things, bounty and hidden treasure, or for similar reasons in the name of such as Banamati, Mata Mantra, assaulting any person, parading naked, or put a ban on his daily activities, or instigate, advise, or encourage committing of such inhuman acts. Ilbarala. Now, my lord, kindly go to 2. To create an impression by declaring that a power inapprehensible by senses has influenced one's body, or that a person has possessed such power, thereby create fear in the minds of others, or to threaten others of evil consequences for not following the advice of such person, or deceive, defraud and deter him. ಎಲ್ಲಿಗೆ ಬರ್ತಿದ್ದು? ಏನ್ ಮಾಡಿದೆ ಅಂತ 1, 2, 3 ಬರೋದಿಲ್ಲ, ಬಾಕಿದ್ರಷ್ಟು ಇಲ್ವೇ ಇಲ್ಲ.
ಬಾಕಿದವರು
ಬರೋದಿಲ್ಲ. ಇದು ಕಂಪ್ಲೀಟ್ ಆಗಿದ್ದಿದ್ರೆ, ಇದು ಯಾವ್ದಾದ್ರು 1, 2, 3 ಕಂಪ್ಲೀಟ್ ಆಗಿದ್ದಿದ್ರೆ ಆವಾಗ 307 ಆಗ್ತಾ ಇತ್ತೋ ಏನೋ, ಅದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಇಲ್ಲಿ 307 ಏನು? Well, now kindly see 380. Yes, alleged 380.
theft.
theft of jewelry. When? About 4 years ago. Not today. About 4 years ago, I stole the jewelry.
Mother-in-law's jewelry.
ಕಂಪ್ಲೇಂಟ್ ನನ್ನ ಮೇಲೂ ಇಲ್ಲವೂ ಇಲ್ಲ, ಸರ್ವೆಂಟ್ ಮೇಲೆ ಕಂಪ್ಲೇಂಟು. ಈ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಎಲ್ಲ ಆಯ್ತಲ್ಲ, 3 ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಆಯ್ತು. ಫಸ್ಟ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ವಾಸ್ JNWC, ಕಸ್ಟಡಿ ಆಫ್ ದ ಚಿಲ್ಡ್ರನ್. ಅದು ತಗೊಂಡ್ವಿ ನಾವು, ನಮಗೆ ಕೊಟ್ಟರು ಕೋರ್ಟ್ನವರು. Second proceedings was filing a complaint against him for an offense under the 490/80 and 3/4 of the Dowry Prohibition Act. Third proceedings ಏನಾಯ್ತು ಅಂತಂದ್ರೆ, I would file a petition against him seeking for a decree of divorce on the ground certain allegations which I have made. ಆಮೇಲೆ ಈ ಕಂಪ್ಲೇಂಟ್ ಅವ್ರು ಸ್ಟೇ ತಗೋಬೇಕಾದ್ರೆ some inaccurate submission has been made stating that he has filed a complaint against me, therefore I have filed a complaint against. No, that is incorrect. I can give you, lordship, the dates. Have a look at the dates, madam.
No, first petition for divorce is by you.
My complaint was of mine, petition was mine, everything was mine. ಅವ್ರದು after thought. ಇದೆಲ್ಲ ಆದ್ಮೇಲೆ he goes and files a private complaint. In fact, my lord, what the Supreme Court has said is, we have a common notion that under section 468 of the CRPC, my lord, the prohibition is imposed only upon the court. No court shall take cognizance of an offense excepting upon a complaint filed within a period of so and so. ಇಲ್ಲಿ theft ಏನು ಅಂತಂದ್ರೆ, the maximum punishment that is permitted under the law is 3 years. ಇವ್ರದ್ದು ಅಫೆನ್ಸ್ ಯಾವಾಗ ಆಗಿದೆ ಅಂತಂದ್ರೆ 2020 ಜನವರಿ,
Complaint
ಫೆಬ್ರವರಿ 2023, ನಮ್ದೆಲ್ಲ ಆದ್ಮೇಲೆ
1 month after the limitation.
ಅಲ್ಲಿಗೆ they can't contend that it is a case that is a prohibition imposed upon the court from taking cognizance. Even a prohibition is imposed upon the policeman from taking the complaint is a law laid down by the Supreme Court.
No. That should not be mistaken. Cognizance can be taken after 10 years.
ಮಾಡ್ಬೋದು.
It is the act of the
Complaint-
complainant to
complaint-
file a complaint within
ಇಲ್ಲಿ
limitation.
what the
That
Supreme
is not the
ಅಲ್ವೇ?
law is that cognizance ತಗೊಳಕಲ್ಲ.
ಅಲ್ವೇ?
Complaint
Yes.
ಮಾಡಕ್ಕೆ 3
Complaint
years ಒಳಗೆ
filed
ಮಾಡಿರ್ಬೇಕು.
within a period. But what the Supreme Court has said is, even when you go before the police, you should be well within time.
Yes.
The period that is prescribed is what the Supreme Court has
See,
said.
ಈಗ complaint is entertained. The court at its own ease takes cognizance after 7 years. That would not absolve the
ಅಲ್ವೇ?
accused.
ಅಲ್ವೇ?
It is only the
The policeman
victim.
ought not to have registered the crime at all. But that is what the
clear.
Supreme Court has said.
ತಾರಾ ಮ್ಯಾಥ್ಯೂ ಅಲ್ಲಿ ಹೇಳಿರೋದೇ.
ಅಲ್ಲ, ಇದರಲ್ಲಿ ಭರತ್ ದಾಮೋದರ್ ಕಾಳೆ ಕೇಸ್ನಲ್ಲಿ this is what the Supreme Court would say in paragraph 10.
No, the constitution bench in Sarah Matthew clarified this, saying that it is not, limitation does not run on the date on which the court takes cognizance, but
The date
on
of
the
filing
date
of
on
the
which the
complaint.
complainant registers the
ಅಲ್ವೇ?
complaint.
ಅಲ್ವೇ?
Cognizance ಗೂ 468 ಗೂ ಸಂಬಂಧನೇ ಇಲ್ಲ.
Otherwise, my lord, everybody would contend for no fault or sin on my part on account of some laches negligence on the part of the court. Why should I be
That is
thrown?
true. No, that
thrown
is why
out?
Supreme Court has clarified. Cognizance has nothing to do with limitation.
Well, just
Yes,
refresh
yes.
my lord's memory. I shall read this only 2 or 3 sentences from this paragraph 10, my lord. On facts of this case and based on the arguments advanced before us, we consider it appropriate to decide the question whether the provisions of chapter 36 of the code apply to the delay in instituting the prosecution or to the delay in taking cognizance, as my lord has pointed out. As noted above, according to the learned counsel for the appellants, the limitation prescribed under the above chapter, that is 468, 469, 470, 471 and onwards, chapter applies to taking cognizance by the court concerned. Therefore, even if a complaint is filed within the period of limitation mentioned in the said chapter of the court, if the cognizance is not taken within the period of limitation, the same gets barred by limitation. This argument, well, it seems to be inspired by chapter of the heading in chapter 36 of the code, which reads thus: limitation for taking cognizance of certain offences. It is primarily based on the above language of the heading of the chapter.
No, that is, I have not proscribed to that at all till now.
The argument addressed on behalf of the appellants that the limitation prescribed by the said chapter applies to taking of cognizance and not filing of the complaint or initiation of the prosecution. We cannot certainly accept such argument because a cumulative reading of various provisions of said chapter clearly indicates that the limitation prescribed therein is only for the filing of the complaint or the initiation of the prosecution and not for taking cognizance, as my lord has pointed out.
There is a judgment of the coordinate bench which says cognizance runs limitation.
ಇಲ್ಲಿ
Cognizance will ಎಷ್ಟೋ ಸರಿ ಇಲ್ಲ magistrates will not have taken cognizance for 10 years.
ಬಿದ್ದಿರ್ತಾರೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಫಾರ್ ಒನ್ ರೀಸನ್ ಆರ್
ಹಾ ಮತ್ತೆ
ಇವರು ಇದು ಅಫೆನ್ಸ್ ಡೇಟ್ಸ್ ಬ್ಯಾಕ್ ಟು January 2020.
all right.
ಇವ್ರ ಕಂಪ್ಲೇಂಟ್
24. That will see, will answer that.
ಅಲ್ವೇ
23, please.
23 February
February
2023.
Offense
But
record of major
what I would do theft of jewelry ಇವ್ರು ಹೇಳುದು ಅವ್ರ ಮದರ್ ಇಲ್ಲ ಅದು ತಗೊಂಡ್ ಅವ್ರ ಮದರ್ ನಾವು ತಗೊಂಡ್ಬಿಟ್ಟಿದೀವಿ ಅಂತ. But I would file a complaint complaining of certain offenses under 490 3 and 4 of the dowry prohibition. In my complaint, I would say, my lord, the jewelry, costly jewelry worth more than about 1.5 crores was given to my daughter. Now the Tanishka now, I am the proprietor of Tanishka jewelry now. ನಮ್ಮ ಮಗಳದು ಕೊಟ್ಟಿದ್ದೀವಿ ಅಂತಿದೆ. During the course of investigation, what the investigator does, he would seize certain ornaments which were in the house. Course of investigation, what the investigator does, he would seize certain ornaments which were in the house. And then ultimately the court would deliver those custody of those jewelries to me. My lord, 2 bank lockers were found by the investigator during the course of the investigation. He would issue a communication to the banker saying that till I issue further orders, do not permit opening of the lockers. But in the meantime, he would rush before this court, even before the lockers are opened, and get an order of stay of recording of further proceedings. But if these 2 lockers are opened, my jewelries are there. Probably, my lord, his mother's jewelry may also be there. I do not know. May be there. Kindly let him consent in all fairness and in fitness of things. Kindly issue a direction to the investigator to open the lockers. Let us see whether his jewelry, which he has described in the complaint, is available there or not. 2 ಲಾಕರ್ ತುಂಬಾ ಇದೆ. ನನ್ ಜ್ಯುವೆಲ್ರಿ 2 ಲಾಕರ್ ಇಟ್ಕೊಂಡಿರೋದು ಮನೆಯಲ್ಲಿ ಬೀರುನಲ್ಲಿ ಇಟ್ಟಿದ್ರಂತೆ ಅವ್ರ ತಾಯಿ ಜ್ಯುವೆಲ್ರಿ. ಮೇಲೆ ಇಟ್ ಲುಕ್ಸ್ quite recently, my lord, just about a week back, I remember to have read a judgment of the Kerala High Court which said, my lord, an allegation simpliciter in the complaint is always there that would constitute an offense. But what needs to be examined by the court when it exercises jurisdiction under 482 or under 226 of the Constitution is the overall picture, the overall circumstances.
So that's what the Supreme Court, not
Just
Kerala High
last
Court.
week.
Muhammad Ali versus
Alright.
State of Uttar Pradesh.
Following that judgment, my lord,
Justice Partiwal has said, it is the duty of the court exercising under 482 to read between the lines,
Alright.
look at the attendant circumstances, then see whether the offense is really made out. Merely because a cognizable offense is made, don't dismiss
But
the
every
cases.
complaint, my lord, it is easier to make an allegation, my lord, indicating the commission of a crime. Oh, I have the jewelry, he has committed theft about 3 years back. ಹೇಳ್ಬಿಡ್ಬೋದು ಸುಲಭವಾಗದನ್ನ ಅಲ್ವೇ? The totality of the circumstances, the backdrop of the matter, I go before the court, I file a complaint, my lord, I file a divorce petition, I wanted the custody of my children. Later in point of time, my lord, he would come up with a complaint against me, complaining of an offense of theft, and then attempt to commit murder, and then, my lord, an offense under section 3 of the Karnataka Black Magic Act. My lord, ಇಲ್ಲಿ ಒಂದು ಸ್ಟೇ ಆರ್ಡರ್ ಕೊಟ್ಟಿದಾರಲ್ಲ ಅವರಲ್ಲಿ 498A ನಲ್ಲಿ. Kindly have a look at that, my lord, the order.
ನಾನೇ ಕೊಟ್ಟಿರೋದ?
ಇಲ್ಲ ಇಲ್ಲ.
Gold ornaments also consent to do away with the life of the mother-in-law.
No, my lord, this is the order.
6/10/2023.
Yes, my lord, 610.
Ah.
Kindly read. Learned counsel for them. I don't
Not-
say, my lord, it is a false statement. I don't say it. It is an inaccurate statement, I would only say. Incorrect statement, I would say. This has probably swayed in the mind of the court to grant an interim order.
The coordinate bench.
Learned counsel for the petitioner submitted the petition number 1 has lodged the FIR against the second respondent alleging committing of theft of gold ornaments and also conspiring to do away with the life of the petitioner to mother-in-law. Thereafter, the second respondent has lodged.
Actually, the other way.
ತಪ್ಪು ಇದು. ಅಲ್ಲ, incorrect statement.
Pointing it out, not the, what I pointed out.
ನಾನೇ ತಪ್ಪು ಅಂತ ಹೇಳ್ತಾ ಇಲ್ಲ, ಸುಳ್ಳು ಅಂತ ಹೇಳ್ತಾ ಇಲ್ಲ. It is this, my lord.
To produce, not the complaint. I have not,
ಅಲ್ಲ, quite
All right.
Immel, I am not finding fault with you, sir. ಏನಾದ್ರು ಉಂಟಾ?
please.
ಛೆ, ನಾನು ಹೇಳೋದೆ. Probably the court, the coordinate bench of this court, my lord, might have been swayed by this and granted stay. ಅದರಲ್ಲಿ ಲಾಕರ್ ಓಪನ್ ಮಾಡಕ್ಕೆ ಅವಕಾಶ ಆಗ್ತಾ ಇಲ್ಲ. ಎಲ್ಲ ನನ್ನ ಜ್ಯುವೆಲ್ಲರಿ 1.5 ಕೋಟಿ ರೂಪಾಯಿ ನಾನು ತನಿಷ್ಕ.
We'll decide it once for all. Now,
Your lordship may.
you can open all the lockers.
Yes, yes, yes.
ಅಷ್ಟೇನಾ? heard the learned counsel.
Well,
Siddharth sir.
probably whether the provisions of
That I am going to answer.
yes.
Black Magic Act,
No.
there is no judgment ಅಲ್ಲ.
ನಾನು ಎರಡು ಜಡ್ಮೆಂಟ್ ಸಿಕ್ತು ನನಗೆ.
ಹಾ.
ಒಂದು ಮಹಾರಾಷ್ಟ್ರದು,
ಹಾ.
ಇನ್ನೊಂದು ಗುಜರಾತ್. ನಾಟ್ ಅಂಡರ್ ಸೆಕ್ಷನ್ ಇದರಲ್ಲ ಬ್ಲಾಕ್ ಮ್ಯಾಜಿಕ್ ಆಕ್ಟ್ ಅಲ್ಲ.
ಹಾ.
But whether the provisions of the Maharashtra Black Magic Act or the Gujarat Black Magic Act are in parameteria with Karnataka Black ನೋಡಿದೆ ಇಲ್ಲ. ಅದರಲ್ಲಿ ಏನ್ ಮಾಡ್ತಾರೆ ಅಂತಂದ್ರೆ they will issue a
The
direction.
black magic in every state differs,
Every
so
state
it can't be the same.
ಇಲ್ಲ, ಅದಕ್ಕೆ ನಾನು they are not in parameteria. Even otherwise in that judgment, my lord, what the Maharashtra High Court would say, Bombay High Court would say is it would issue certain directions to the state government to frame certain rules.
ಇಲ್ಲಿ already ಇದೆ.
ಇನ್ನೂ ಆನ್ಸರ್ ಮಾಡಿಲ್ಲ ಇದನ್ನು.
This should be the first judgment.
The first judgment. ಅದಕ್ಕೋಸ್ಕರ my lord, I may win, I may lose. That is not the issue. If my lord were to lay down the law, my lord, that would be of some use for future litigations.
Yes, yes. Unless I am hit by black magic. Yes. Heard the learned counsel so and so and learned senior counsel C.V. Nagesh appearing for the respondents. All three matters reserved.
Please,
Yes.
oblige.
Interim order in my
Interim
case-
order subsisting in any of these cases in the form that it is subsisting continues till the disposal of the petition.
Please.
Please. Sorry, my lord. Because
No
unavoidable.
problem, sir. Just say it. ನಿಮ್ಮನ್ನ ಕೇಳಿದ್ನಲ್ಲ ಅವತ್ತು ಅದಕ್ಕೆ ಅದನ್ನ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
ಅದು ಅಲ್ಲಿ ಈ ಪಾಲಿಟಿಷಿಯನ್ಸ್
ಓ ನೀವು ಆ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇವರು ಅಲ್ಲೇ ಇದ್ರೇನು? ಓ ಸರಿ.
ಹೌದು, ಇಬ್ರು ಅಲ್ಲೇ ಇದ್ವಿ.
ಅದೇ.
I was relieved by 425.
Yes, yes, sir. ಏನಾಗಿದೆ ಮೇಡಮ್?